Hello, my name is Matt Warnzak. I am an intellectual property attorney with Smith, Gambrell & Russell. Today, I am talking about patents in general, including what they are, why people acquire patents, how patents are procured, and how they are used. The goal today is for you to have a better understanding of patents, including their value and how to obtain one for your invention. Patents are a limited monopoly, which exclude others from practicing an invention. In exchange for this monopoly, the inventor, through their patent, discloses to the public how to make and use the invention. Patents are used throughout the world. However, for today's purpose, we will focus on the U.S. patent system. In the U.S., there are three types of patents: design, plant, and utility. When people are discussing patents, they generally mean utility patents. Patents are used to protect people's new inventions or improvements thereof. A well-known phrase, at least to patent attorneys, is that, outside of a few exceptions, anything under the sun that is made by man can receive a patent. Patents can be acquired across all fields of technology and for any process, machine, article of manufacture, or composition of matter. Now, what do these categories mean? Let's look at them through the development of a new and improved high-strength fabric. A patent can be acquired for the process for making the new high-strength fabric, the machine on which the new fabric is made, the high-strength fabric itself, that is, an article of manufacture, and a new type of polymer, a composition of matter, utilized in the high-strength fabric. And while almost any new invention can receive a patent is not needed for inventors to practice their invention. Now, if that's the case, then why would an inventor consider getting a patent? Well, because a patent is an asset. First and foremost, patents can exclude others from practicing your invention. Patent owners can prevent any type of use of their invention by others, creating a barrier for competitors to enter the market. Additionally, patents generate money for the patent holder through licensing agreements. Also, since patents are a form of property, they can be sold and transferred. In addition, having patents can lead to investors providing funding for commercial development of the patent, which is especially common with startups. Patents can also lead to desirable partnerships for the patent owner, or can be used as a defensive bargaining tool when a patent owner is sued for patent infringement themselves. Lastly, patents can have marketing value. Who wouldn't want to advertise that their product is patented? Now, having an invention does not automatically get you a patent. Inventors must submit a patent application to the United States Patent and Trademark Office, commonly referred to as the USPTO, for its review. The USPTO will determine whether or not the invention, as described in the patent application, is patentable. The patent application must meet several requirements in order to be patentable. First, at the most basic level, the patent application must specify, in a section of the application called the claims, what the inventor asserts is her invention, as well as clearly describe the invention in a section of the application called the specification. The specification is the written description of the invention and can include figures that help illustrate the concepts of the invention. The specification should provide enough information so that a person with an average understanding of the field of technology can make and use the invention herself. The claims are the most important part of patent applications. The claims specifically define the extent of protection sought in a patent application. In other words, the claims are similar to a fence, carving out what the inventor asserts is her invention to keep people from practicing. In other words, the purpose of the claims is to define the subject matter sought to be protected. This is why the examination by the USPTO focuses on the claims. The USPTO, through an examiner, will determine if the claims are patentable. Examiners can reject claims on several grounds. Claims can be rejected if they are directed at abstract ideas, like mathematical formulas, or computerized, well-established business practices, and natural products and phenomena, such as photosynthesis. The examiner can also reject claims if earlier published materials, like printed patents and patent applications, journal articles, advertisements, and the like, disclose the invention individually or in combination. Referring back to the fence analogy, you can't stake a claim in an area already being used or known by others. Likewise, actions of the inventors themselves that occurred before the filing of the application, like public pitches, sales of the invention to another, and public use of the invention can invalidate the claims for the same reasons. Once a patent has been granted, the patent owner can go after people practicing their claimed invention, known as patent infringers. However, there are some limitations. First, a patent owner's rights only extend to the invention as specifically claimed in the patent. That is, if a competitor's allegedly infringing product does not include every element found in the claim of the patent, the competitor cannot be found to be infringing that claim. In addition, a U.S. patent can only be enforced within the United States, which is exclusively handled by the federal court system. Further, a patent has a finite lifespan of 20 years from the date of filing. Once a patent expires, the invention is free to be practiced by the public. This has been a brief overview of patents and their importance. The patent process is the most complex and expensive area of intellectual property law to navigate, and it is highly recommended that patent counsel be obtained by inventors to handle the drafting and prosecution of a patent application. The State Bar of Georgia and the USPTO have programs to assist first-time inventors find experienced patent counsel. If you have any questions, please don't hesitate to visit the State Bar of Georgia website at www.gabar.org.